Good evening, friends. Two issues I want to talk about in relation to the Finance Bill 2022. One is on capital gains. A very welcome change has happened where capital gains on unlisted securities, real estate, etc., any long-term capital gains, the tax rate has been reduced because they have slashed the surcharge from a highest slab of 37% to 15%, which effectively means that for a HNI who falls into the highest tax bracket, earlier the long-term capital gains tax rate was 28.5%, that has come down to 23.92%. So an almost 4.6% reduction in the tax rate. So any clients or HNIs who are looking at doing any deals where they might incur long-term capital gains would be well advised to take advantage of this rate in April 2022. So if they are planning to close the deals today, they would be well advised to postpone this to April 2022 because there is a significant benefit in the tax rate. The other issue is more of issue which arose because of a Supreme Court judgment. So essentially what happened was there were a few companies that were merging in the Maruti Suzuki group, and tax notices were sent to the amalgamating companies when the process of merger was on, and the Supreme Court held that those tax notices were invalid because those companies are no longer in existence. That presented a very peculiar position because then that meant that because the notices were not sent to the amalgamated company, the opportunity for the tax authority to assess the income of the amalgamating companies was gone. To clarify and to address that anomaly, what has now been provided is that if any assessment is being carried out in the predecessor company, then that will be deemed to have carried out on the successor company or the amalgamated company. So that's one thing. The other thing is because the merger amalgamation process of NCLT sometimes takes a lot of time and you have to give effect to the merger from a particular date. So what happens is that the income has to be offered for a particular year, but the order comes maybe a year after, maybe sometimes 18 months after, sometimes 2 years after. The time for a revised original return is gone and time for a revised return is also sometimes gone. So you are not able to do anything, and then there is always an issue as to how can you offer this particular income of the amalgamating company in the hands of the amalgamated company. So now what has been provided is that 6 months from the date of the NCLT order is the time available to file a return, a revised return, on account of any changes due to amalgamation, demerger, etc., which is again a very welcome provision. Thank you so much.